Our next speaker up is Todd Clement, and he's a personal injury lawyer and a national expert in cell phone litigation issues. He's a sought-after educator and a speaker on distracted driving, and Todd is considered to be the go-to expert and has been featured on national news programs including NBC Nightly News with Brian Williams and CBS This Morning. Todd is consistently recognized as a national super lawyer and best personal injury lawyer list, and he told me to tell y'all to ask him later on about the affluenza case, if y'all know what that is, to give him. So he said he's just not a cell phone litigation, but he does other really cool cases too. He was on the only 100 Texas lawyers selected for membership to the National Trial Lawyers Association and is currently the president of the Dallas Trial Lawyers Association. Todd has successfully handled numerous car, truck, and commercial vehicle cases involving distracted driving that resulted in an injury or a death. And today, Todd will review legal and corporate liability and what it means for companies with their employees are driving distracted. So welcome to us today, Todd Clement.
Thank you. Hi, guys. Boy, doesn't Dave Teeter set a high bar. You know, it's kind of amazing because I look out here and I see a lot of folks, and it's really exciting to have you here, but my guess is that there's a lot more folks out here than I see. And I want to try to get a feel because I always like to know who my audience is. So anybody in here that drives or supervises drivers in connection with their business, their everyday business, I want you to stand up, please. Just stand up. If you're driving your business or you supervise drivers in your business. Pretty good crowd. Now, I've got a method to my madness because if you are with a company or you represent a company that has at least 10 drivers that drive in your business, stay standing. The rest of you sit down. At least 10 drivers. Okay? Still quite a few of you, so we can multiply everybody that's standing up by 10. If you're with a company or a business or a governmental entity that has over 100 drivers that you're part of their business, stay standing. Okay, so boy, that 100, my math's not good, but I've got, looks like at least 70 or 80 times 100. Now let's really start the math. 1,000 drivers that you are a part of, stay standing. Holy cow. Okay, I'm really starting some serious math here. Now, I'm going to go 5,000 because I'm not going to go 10. 5,000 drivers. Do I still have any 5,000 drivers? Wow. 10,000 drivers? Still got a few. Okay, so that's my impression. You can sit down now. Mostly I just like a standing ovation. Y'all can clap while you're standing up. All right, so that's the lesson that I want y'all to know. It's not just 200 of us in here. It is hundreds of thousands of us in here. Now, this afternoon, you're going to get a panel, and Dave's kind of sweet about this problem of distracted driving. We call Dave the carrot, meet the stick, okay? Because my job is to tell you what happens if you don't have a good distracted driving policy. And it starts really simple. Trial lawyers have an important role in our society. I know some of you think that that's absolutely impossible, but let me tell you, we do. We are part of the check and balance on the American capitalistic system. And let me give you the best example in the news right now. How many are real proud of General Motors in light of what y'all have seen in the last few months about the auto ignition problems and things such as that? How many of you are old enough like me that have no hair or gray hair that remembers the Ford Pinto, the Firestone tires, things like that? Because indeed, but for the litigation system and trial lawyers, those problems would have never been brought to light and those problems would have never changed. So, where do we have to start with this problem with distracted driving? We have to start with a question. And that question is, what motivates jurors to award large damages? Now, I graduated from Texas Tech University in Lubbock, Texas, back in 1986. I know y'all think I'm much, much younger than that, but really it was 86. And indeed, back in 86, when I got to be a lawyer, the conventional wisdom was that what caused big jury verdicts was sympathy or outrage. And indeed, once in a while that does work. But we have spent a great deal of time, a lot of psychologists and really smart guys have spent a great deal of time in the last 10 or 15 years looking at what causes large jury verdicts. And primarily it's not sympathy, primarily it's not outrage. Instead, it is the more base level of the human brain. Some people call it the reptile brain. Indeed, it is what makes us who we are. And that base level of our brain values two things more than anything else. That is self-preservation and preservation of our young and protecting our young and our species. Now, let's think about this a little bit and let's see if, anytime somebody makes a statement, you've got to figure out if it makes sense. Does it make common sense? Well, how many of us have known the sweetest little mama dog that we've ever known in our lives that would no more snarl, bite, or anything else at anybody than nothing, but the minute they have a puppy and you get close to them, they turn into a Rottweiler? Also, think about it this way. How many of us would put our own lives in peril to protect our children? Almost all of us, I would hope. So that tells you what that indeed jurors are motivated by. Now, my favorite argument that gets raised against me in every one of these cases is the everyone does it defense. Because let's face it, folks, we can sit up here and talk till we're blue in the face, but the majority of people do it. And everybody thinks that that's going to be a good defense to a personal injury lawsuit if indeed a catastrophe strikes. Well, I'm here to tell you that cell phone use while driving is the one thing that most people want to do themselves, but which they desperately want others to stop. Now, at the beginning of every trial, there's a very small period of time called voir dire. And that's the time that I get to talk directly to the jury, and they get to talk back to me, and I get to determine what their general feelings are about various issues. And so we're going to play the beginning of a trial right now as if this was voir dire. And I'm going to ask you some questions, and I want you to raise your hands. How many of you have seen someone drive dangerously while using their cell phone in the last year? Raise your hand. Okay, pretty much everybody. In fact, look, let's face it, folks. 10 years ago, when you saw somebody driving like a fool, especially some of you officers, the first thing you thought, indeed, was they're drunk. That's why you pulled them over, because you had reasonable suspicion that they were driving like an idiot. Now what's the first thing you think of? Get off your dang phone. That's what we all think when we see somebody doing something stupid on the road. Get off your phone. How many of you have feared for your safety because someone was using their cell phone while driving in the last year? Raise your hand. Pretty much everybody. How many of you have talked on your cell phone while you drove in the last year? How many of you have texted or emailed, old guys, that's us, emailed on your phone in the last year while you drove? Okay. So what I've shown you guys is that indeed the problem is recognized, but you still do it yourself. But I got to tell you, back in the jury room, it creates results, because indeed a jury is motivated to send a message. A large jury verdict in a cell phone case is the one way that jurors believe they can protect themselves and their young by sending out a large jury verdict. It is proven. This is not anecdotal. If you'll go on the National Safety Council website, you will see a white paper called Employer Liability. And indeed, that was something that Dave Teeter's staff, particularly Deb Tromley, and I worked very closely together to establish a white paper. And at the end of that white paper, there is a listing of significant jury verdicts and settlements involving cell phone use. And I will tell you, even in small cases, they could be exponential. Now, the tagline I invented when I started talking about this about 4 years ago was DWD, driving while distracted, the new DWI. And I did that for one simple reason. We have got to treat this like an epidemic. We've got to treat this like a problem, because if we don't, then indeed it's going to continue. And I think that tagline, DWD, if you're talking to your staff, if you're talking to your drivers, I think that's a good tagline to say. Now, you've heard some discussion of my good friend Dr. Dave Strayer out of the University of Utah. And these aren't just talking heads. Dave Strayer was the gentleman that ended up, some of y'all remember Oprah's No Phone Zone program that came on, it was around 2010, 2011, and Dave Strayer was the one that she got up there to talk about the science. And on top of it, Dave Strayer was also, his studies were what was cited by the New York Times in a Pulitzer Prize winning series of articles on distracted driving. This guy was kind of the pioneer. And you heard Dave Teeter talk to you about the comparison between cell phone use and driving while intoxicated at 0.08. And indeed, you know, the studies don't lie. I can sit up there and as a trial lawyer, I get to make very simple analogies that jurors understand. And I get to argue that, ladies and gentlemen, and I'll put up the scientist. I'll put Dave Strayer up. I put him up more than once. Or I'll put another guy, a good friend of ours named Paul Atchley out of the University of Kansas. These are the two kind of the gurus of this area. They will testify that driving while using a cell phone has the same or worse crash risk than driving while intoxicated at 0.08. They will also testify that driving while texting, ladies and gentlemen, is much, much, much worse than 0.08. So I get to argue to the jury that indeed, imagine how a jury would react if an employer regularly knew about and profited from its employees driving while intoxicated. Because that analogy works all day long. Those of you that say, I can't afford to have a policy because it's going to cost me money, you're playing into my hands, ladies and gentlemen, because that's what the Ford said with its Ford Pinto. They did a study that showed that fixing the Pinto was more expensive than the wrongful death cases they were going to have to pay out. And I've got to tell you, the juries there showed them that it was going to be a whole lot more expensive for the wrongful death lawsuits than it was fixing the Pinto. That's a layup for me, folks. That's easy. So if that's the argument you're going to make, it doesn't work, because as a practical matter, that's what an employer without a cell phone ban is doing by allowing and profiting from driving while distracted. And that's what you're doing. If you're using your cell phone in your business, I get to argue that you're profiting from it, and you've got to own it. Now, every single time I do one of these seminars, I get some basic legal questions, and I'm going to try to anticipate a couple of them. We'll probably answer a whole bunch of them this afternoon as well. A couple of questions are, how can I be liable for what happens to my employees while they're on the job? Okay, so there is a law called respondeat superior. And lawyers, this is a little secret that y'all will learn if you ever deal with a lawyer. Lawyers get to charge triple for Latin, so that's why we use these funny words. And indeed, respondeat superior means that when you are in the course and scope of your employment, when you're on the job, your employer is responsible for anything you do. All right, so what does that tell you? That tells you anytime someone is conducting your business, you're writing a check for anything they do. So that leads to the second question I hear a lot of times. Well, they got their own cell phone. How can I control what they do? Pretty good argument. Okay, wait a minute. Can you control them drinking a six-pack while working on your job? Can you? You know, do you have the right to tell somebody they can't do something dangerous while they're working for you? You bet you can. That's a cop-out. Now, can you control it 100%? I was talking to a gentleman during the break, and he owns a moving company. And you're going to hear from him this afternoon, and he's going to talk about what they've done to stop this. And the argument always is, well, what if I'm not perfect? What if I've got a policy and my employee doesn't follow it? Well, if you're following Dave Teeter's best practices, if you've got a policy, you're educating and you're enforcing it, and you've got a rogue employee, I got to tell you, I'm like an old tiger whose teeth are pulled. I'm just doing like this. Because the truth of the matter is, I don't get the argument to a jury that this is a business that's profiting from dangerous activity. I don't get the argument that you've got to send a message to that business. I've just got an employee that was a rogue employee that didn't follow the rules, whatever. That's not nearly as good a lawsuit. It's not going to be worth near as much money. So it's not one of those situations that if I can't be perfect, I shouldn't try. Because if that's the standard, we'll never satisfy it. The answer is, can I do better? Can I follow the best practices, and is it worth it to my business? And I'm here to tell you as a trial lawyer, as someone who profits from bad behavior, I don't want any more bad behavior. That's why I'm here today, ladies and gentlemen. You're going to find out in a few minutes, just like Dave, I've got a little bit of my own story, though not nearly as personal as Dave's and others here and Jennifer's, but I've got my own story of why I'm here. I'm not here to generate business. I'm here to stop business. So let's talk about what happens when one of your drivers is involved in a bad collision. And Dave said something that's really, really important. There is no BAC for cell phone use, and it's terribly underreported. In fact, Kate Snow with NBC Nightly News did a major story about 6 weeks ago on the fact that this is perhaps one of the least identified sources of collisions. Not because law enforcement are blowing it at all, it's because we haven't given them the tools to do their job to really investigate this particular issue. There's some really great technology coming down that will allow law enforcement to capture somebody's cell phone at the point of impact, at the time of the collision in a catastrophic collision. But most of the time, the cell phone stuff is not really known by the time a catastrophic collision gets to me. So what do? I presume that it's involved in every single case. Because we all know there are certain kinds of collisions that sort of feel like cell phone collisions. And let's talk about what those collisions are. Rear-end collisions are absolutely number one on any kind of cell phone collision. And why? You heard Dave talk about things like lack of situational awareness, inattention blindness. These are the things that somebody's just going along on autopilot. And I like to use that word because we've got to convince you guys you got a problem. Your question of me is going to be, if this cell phone use is so bad and I've been doing it for so long, why haven't I been in an accident? Because I've got to convince you got a problem. Well, let me tell you, we've learned how to drive on everyday roads pretty well using our cell phones, or we would have a billion crashes. But it's kind of like autopilot. Generally, if nothing terribly surprising happens, we're going to get home okay. We all do. We all have. But when something unexpected happens, when traffic unexpectedly stops in front of us, when somebody cuts in front of us, we have a lack of situational awareness to what happens. It takes our brain longer to reboot and to think about how they need to react. In fact, Texas A&M, our good friend Joel Cooper that now works with Dave Strayer at University of Utah, headlined a study that Texas A&M did showing that indeed the lack of response time with cell phone use is a huge problem. Why is response time a huge problem? It makes a crash more likely to occur, and if a crash does occur, it creates a worse crash. You know, our cars, I got to tell you, when I first started in this business, I'd look at a bad car wreck and I would go, that person has got to be dead. You know, they've got to be maimed, injured, whatever. Now, I see a bad car wreck, and I'm almost surprised, especially rear-end collision with airbags and things like that. I'm almost surprised that people didn't walk away. Our cars are so much better engineered today than they ever were before, that indeed, you know, but when you add an extra 25% to the velocity of an impact, that creates an exponential bigger risk of injury. So that's why we got to really watch that. So again, rear-end collisions, running red lights without touching your brakes or running stop signs. I can't tell you how many of those cases I've had where I never saw the light, I never saw the stop sign. Why? Because you are straight ahead. You know, maybe there's a tree over the stop sign. Maybe there's a car over there so that you don't have knowledge that that's a stop sign, and that's not something that you regularly do. That's the kind of accidents we have. So what do? Well, we immediately dig for what I call cell phone gold. In the civil process, unlike criminal, we have the ability to go fishing. And when I talk about fishing is we go fishing for finding out evidence. And what is the first thing I do in every major collision? I subpoena the driver's cell phone records. Now, what does that show me? What does your employee's private cell phone records tell me? Most of you guys are familiar with simply the normal cell phone records that simply shows the time of the call and how long the call is, right? Most of y'all have seen those records. Well, I can get something called cell tower records. Anybody here know what a cell tower record is? Okay, cell tower records tell me where the call began and where the call ended. Real simply, those of you that handle trucking companies, it will tell me that a call began in Austin and ended in Temple. What does that tell me? Person was on the road during that period of time. Why is that important? It tells me that they're on the road on their cell phones. Also, you can get, very rarely can you get the actual text content, but you can see the ping, 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 ping of texts. Because that will tell you, if you look at the times, that indeed they're sitting there talking on their phone and doing that. So cell tower records, why is that important? Well, let me tell you guys that handle trucking, because that's what I primarily do is catastrophic trucking cases. I use cell tower records to audit truckers' logs. Because indeed, if their trucking logs tell me that they filled up with gas in Texarkana at 11 a.m., but I've got a phone call in Tyler at 11 a.m., that tells me their logs are a work of fiction. So that's something you also need to know. Now, who in here is familiar with the concept of telematics? Raise your hand if you know what telematics is. Anybody in here? Okay, so that's a new big deal in trucking where they use GPS technology on the bottom of vehicles to tell the home base exactly where they are at any given time. And it's sold to companies, particularly trucking companies, as a huge benefit to their company as a cost savings, primarily in terms of gasoline. It tells them whether or not the driver's sitting there idling, running their vehicle. It tells them whether or not they're doing hard stops. It lets them monitor speed, and it's a really cool device. Well, let me tell you another thing it could do. I can sync cell phone records in a catastrophic case with telematic data, and I can tell you everything that driver's doing at any given time. Let me also tell you, if you have telematics and you don't use them to promote safety, you are making a huge mistake. In connection with the case that we're going to talk about later today, you're going to find out that indeed a company, a very large company, a company that's the 10th largest cable company in the country, owned by the Washington Post, had telematics on their vehicle. One aspect of their telematics indeed could have something called speeding alerts. Anytime a driver got above a certain speed, it could send an immediate safety alert to the company so the company could correct that behavior. That was an option. It was a free option. The company elected to turn that option off. After the lawsuit was filed, we got that data and we determined that this particular driver was driving 80 or above on a 65-mile-an-hour stretch of road at least a third of the time over a period of about 6 months. How do you think that played out in connection with the case? They knew about it. They didn't know about it. They had access to the information. All they had to do was click a button. but they chose to bury their heads in the sand. Once again, the single most powerful way to motivate a jury is to tell them that by rendering a larger verdict, they can protect themselves and their family. You need to send a message that this type of a safety program must be followed. So that's what we can talk about telematics. Now, what ends up happening with a lot of you guys is when your driver makes a mistake, they rear end somebody, whatever, they go, look, we admit fault. And truthfully, that is a very good thing to do if you're a defendant. Because if you fight me on something that's obvious, it's going to make the jury even more angry. But let me tell you, in a case involving distracted driving, in a case involving cell phone use while driving, that's not going to cut it. Because indeed, when you have a distracted driving case involving cell phone use or particularly texting, you can't just say, look, it's my fault and we just want to pay for what we owe. No, because I get to argue that conduct wasn't just negligence. That conduct was gross negligence. Gross negligence is egregious conduct that you should have known about. You should have known better, but yet you went ahead and did. And those kind of cases are exponentially more valuable. Now, even if I don't get punitive damages, studies show that gross negligence type of cases are worth considerably more. And again, let me use your common sense. If you break your arm because somebody just wasn't paying attention, they weren't on their cell phone or anything else, and they rear-ended your car because you unexpectedly stopped in traffic, that case is going to be worth X, okay? Relatively benign case. It's just about your broken arm. Somebody made a mistake. It's a broken arm. What's it worth? But if somebody was DWI in connection with that case is worth 4 or 5 times what it would be worth if it was just indeed common negligence. Same thing when you got a cell phone use involved. It is, as I say, cell phone use is gasoline on a fire. But let's talk about what happens if maybe there's a question of who's responsible. I'll give you the example that a few years ago I had a case involving 2 truckers in Kansas that both of whom probably shouldn't have been on the roadway because it was a blizzard. There was not a whole lot of visibility. There was complete snow on the roadway. But we do know they got together, okay? We do know they head-oned each other. It was a glancing blow, but one was in the wrong guy's lane, and it was one of these kind of crashes. Pretty serious, obviously, with 2 80,000-pound trucks. And when the troopers got out there had been too much snow. The tracks had been filled in. And on top of it, what wasn't filled in was just this big mess because 2 trucks had got together. There was not the physical evidence that a trooper could use to definitively determine who was on the right side of the road and who was on the wrong side of the road. But guess what? There was a witness. And there was a witness behind, luckily, the other truck that hit my client. At least that's my story, and that's the way I truly believe it. And we started talking to that witness, and we established that in the minutes prior to this accident, the truck driver was all over the road. He was over here. He was over there. He was not driving in the same lane. In fact, he was driving erratically enough that this witness, you know how you'll do when you're in a bad snowstorm, you'll follow the truck because you could see the truck in front of you, and you got to believe, they're in the ruts. You'll follow them in the ruts. This guy got scared enough that he backed off the truck. And once we pulled the cell phone records, guess what? He was on the phone in a blinding snowstorm in Kansas. And guess what? That case resolved very well 2 days before that trucker was getting ready to be deposed. That was a jump ball case, ladies and gentlemen. That was literally a 50-50 case as to who was responsible till we established one factor. And once that happened, they knew they couldn't win the case. Now, what's the bad news about punitive damages, ladies and gentlemen? Let me tell you a couple of things about that because this is really important for your business. A lot of you guys take the attitude of, I buy insurance to protect me from that risk, and I'm responsible to my company, to my shareholders, by buying that insurance, and if the worst happens, that insurance company is going to pay for this, not me. not my company. Well, let me tell you two things. Number one, remember the Ford Pinto case. There may not be enough insurance bought to take care of the problem if indeed it was a catastrophic event. If you cause somebody to be brain damaged or quadriplegic, or if you kill a large wage earner, or let's just say you kill somebody that is a magnificent human being, you may not be able to buy enough insurance to take care of this problem. Let me tell you number two. In Texas, there's a very real question about whether or not you could even have insurance coverage, even if you bought it, for punitive damages. We have a Supreme Court here that has rendered several different decisions that causes into real question whether or not you can have insurance coverage for this kind of loss. But number three, and all of you that are in your safety department of your business, you'll know that insurance is the one product, if God forbid you ever have to use it, even though you paid all those premiums, you're going to pay the price year after year after year for using it. That's why it does not make good business sense. Now, before I go to the next slide, Becky, is Becky still here? Becky, wave. I'm sorry, I can't. Okay, are the kids still here? Austin, okay. There you are, Austin. Sorry about that, bud. Okay. Let me tell y'all why I'm here. I'm not here to make money. I'm not here today for any other reason other than some pretty spectacular human beings. Some of my favorite people in the world are in this room. You're going to hear from them later on today to some degree, and they're going to start crying. This is my ha-ha. Let me tell you who she is. This is Becky Woodson. Becky lost her daughter and her mother-in-law in a tragic accident. Let me tell you who we got here. We've got Austin Ragsdale. That's Becky's grandson, who lost his mom and his grandmother in a terrible accident. And you're going to hear from Misty Woodson, who lost her sister and her grandmother in a tragic accident 4.5 years ago. That's why I'm here. We got a phone call because their niece or cousin now was the paralegal of my best friend. And we got a phone call one afternoon saying a terrible accident happened near a town that I do a lot of business in North Texas. A mom, Minnie Ragsdale, and her grandmother, Peggy Woodson, were traveling on a busy road that connects Sherman with Bonham, Texas, and Paris, Texas. Those of y'all that know your North Texas geography, you'll kind of know what we're talking about. This is a 2-lane road at the time of this accident, but it is a heavily traveled thoroughfare. There's a lot of folks in that part of the world. That particular morning, Misty had dropped off the kids at school, and she was having some problems with her car. And so she went to her grandmother, Peggy Woodson's house, and Peggy was taking her over to Becky's house to get a car for the day. They were stopped in the roadway to make a left turn into the dirt road that goes to Becky's house. And amazingly, their 3-year-old child, Cody, was in the back seat in a car seat. They were stopped with the turn signal on. Behind them was a 1/4 mile of visibility. Behind them also was a Ford F-150 with a cab on the back owned by Cable One. The driver never hit his brakes and hit them at 70 to 71 miles per hour. Never hit his brakes. Cruise control was on. Knocked him in the path of an oncoming car who then hit them from the side, instantly killing Misty and Peggy. There were angels in that car, though, ladies and gentlemen, and in fact, they come from very modest means, but they had bought the most expensive car seat they could find. And that 3-year-old baby in the back seat only had a broken leg, and you won't imagine the carnage of these cars. In the immediate aftermath of the collision, the driver for Cable One said, "I was texting before the crash. I looked up, it was too late." Now, tells the story a little bit. This is the consequences of driving while distracted. And we talked to Austin before we did this, and Cody's out of the room right now because he's ready. He said he wanted to see what happened. Now, I talked to you guys a little bit about written discovery, and we asked all your cell phone policies. By the way, what happens is when we file this case, we don't just get the cell phone records. We get all your internal policies about cell phone use. Every policy you've got, but not just that. I get you emails talking about it. I get everything that was ever considered to get there. But the thing that most organizations fear the most are oral depositions. That's where it's just like court, where you have to swear to tell the truth, the whole truth, and nothing but the truth. And what happens in cases like this is we start at the very bottom. We start with the driver, and then we just take it up one more step and one more step. So in this case, we started with the driver, and you're going to see Davian testify. Then you're going to see his immediate safety supervisor testify. Then you're going to see the terminal manager, basically the area manager guy testify. Then you're going to see the national safety person testify. And then you're going to see the person in charge, this was their vice president of human resources for this 10th largest cable company in the country, testify. And we take it all the way up. And you know what? You can't answer these. Well, just watch. This is about 8 minutes of actual actual testimony in this case. And this shows how, indeed, we talk about how you cannot win on a distracted driving case. And I'm asking you never saw the Woodson white vehicle before you hit them?
I don't remember seeing them.
All right. Not down the road, not ever? Is that a yes?
No. I mean, yes, that's correct.
If the evidence in this case establishes that you have 15 seconds or more of clear vision of the roadway ahead of you before the actual place of this collision where the Woodson vehicle was traveling, you have no explanation for why you never saw them.
I don't know.
What did you see when you got to the scene?
Pretty horrific scene. I mean, it was, vehicles and damaged, and I mean, it was not a pretty sight. I had EMS people and fire department and police there.
What were you told?
I was told that basically Davian told them that either he had been on his cell phone or he was texting before the accident, and that's what they said he had told to them.
The policy dated November 3rd did not prohibit the use of cell phones or any other communication, but told associates that they need to be aware of it. They need to follow state and city, legislation, follow the laws, and to make every effort to not be distracted with radios, pagers, mobile communications, and basically to try to pull off the road whenever it's possible and whenever it's safe.
What was Cable One's corporate policy regarding texting while driving on January 25th, 2010?
It would be the same as this policy, to not be distracted, to make every effort to not do things that distract you from the road, and to follow the state laws and local laws.
Have you ever seen a single piece of paper from Cable One addressing texting while driving prior to January 25th, 2010?
Not that I recall.
You would agree with me that then a cell phone exposes the public, cell phone use while driving exposes the public to unnecessary risk. This is their own policy.
In some cases, yes.
Okay. What cases doesn't it expose the public to risk?
I think if you're case by case, once again, nobody around and you're stopped and pulled over and in your vehicle, using your best judgment.
As Director of Safety, do you believe that texting while driving company vehicles involves an extreme degree of risk to the public?
I think that it's very dangerous.
Okay. That's the punitive damages standard. Formal written policies at all from Cable One that specifically address texting while driving?
Not that I know of.
My policy is that if you're going to use a cell phone, that you should use it in a manner that's safe, that you should use it in a manner that doesn't cause a problem, and use it in a manner that doesn't cause accidents.
Okay. How do you use a cell phone in a manner that doesn't cause accidents?
I don't know.
When Davian Bennett was hired on May 1st, 2008, what was Cable One's policy regarding cell phone use while driving company vehicles by your field techs?
Well, it was, that we're not supposed to use cell phones while they drove. Just standard,
What did you understand the Cable One policy to be?
As far as cell phone,
Yes, sir.
if you were going to be using cell phone, please be hands-free and to minimize your talk time if you were going to be using it.
So they did not prohibit you from using your cell phone?
You can't prohibit it because even the lead techs, they have company phones that people call them on.
You would agree with me that Cable One has the authority to completely ban cell phone use while driving company vehicles.
We could.
You would agree with me that if Cable One banned the use of cell phones while driving company vehicles, that would eliminate the potential danger posed by cell phone use while driving.
If we wanted to eliminate cell phones so that people who are distracted, who are using them improperly, are safer, yes.
You would agree with me that your policy, as it currently reads, gives your associates the discretion to determine when it is safe to use a cell phone.
Yes.
And your studies, as we've just gone
This
over,
was their expert
your
witness.
recommendations as a result of your studies are that cell phone use while driving should be banned.
Correct.
It's your understanding that these policies, as written, provide Cable One drivers with the discretion to determine whether or not it's okay to use their cell phone or to text. Is that correct?
To use your discretion, yes, correct.
This is a discretionary policy.
Yes.
This is not the kind of policy you would have written had you been writing a policy like this.
I haven't written a policy, but based on my recommendations, that's correct.
You would have specifically addressed it texting and specifically banned it, correct?
Correct. Yes.
So do you believe it's an inadequate policy?
Yes.
There's no question at all that Davian Bennett was a distracted driver, correct?
That's my opinion.
It is also your opinion that a period of 14 seconds, you understand that he had a period of 14 seconds when the Woodson Ragsdale vehicle was potentially visible to him.
Potentially, yes.
For you as a scientist and for you somebody who has studied people being distracted from the roadway, 14 seconds would be a number that is almost inconceivable to you, correct?
That's correct.
So we don't think that's respectful to our associates or reasonable in this day and age to ban communications. We trust our associates to have really great judgment, and that's what these policies are about, and I think that we have done that.
If the evidence in this case establishes that Davian Bennett was texting before this collision, in other words, that it contributed to this collision, would you agree that he used good judgment?
I would be surprised. I've never heard of any of our associates texting and driving. I think texting and driving is a bad decision.
In light of the deaths of Mindy Ragsdale and Peggy Woodson, do you wish you had done anything differently with regard to your cell phone policy?
No.
In light of the deaths of Mindy Ragsdale and Peggy Woodson, do you wish you would have done anything differently? Any of you guys, if that's you in that hot seat, how are you going to answer that question? That's the real question today. That was 40 hours, 50 hours of testimony taken down to 8 minutes of gold. That tape has been played by Dave Teeter all over the country. It's been played by Jennifer Smith. It's been played by me. It's been put on websites. Cable One is still paying the price for that conduct 5 years later. And they will for a long, long time because it's a lesson that needs to be learned. There's only one response that makes business sense, because without a ban, an employer loses either way with me. You either admit that you didn't realize there was a problem. Well, that's kind of ridiculous in light of the storm of media that we've read for the last 4 years. But if you want to do that, that's great, because we're going to ask the jury to teach you a lesson, to tell you. But even worse, you admit that you knew about the problem, but you did not take effective and decisive action. You knew better, but you didn't do better. You know, that's really close to deliberate conduct like the Ford Pinto and things like that, when you know better but didn't do better. And I've got to tell you, those are the cases that the values are exponentially higher. And ladies and gentlemen, guess what? If you're here today, you knew better. Let's see if you do better. So what's the only way that an employer can have reasonable protection? You must have a clear-cut, non-discretionary policy. The policy must unequivocally ban all cell phone use, including hands-free while on the job. Look, folks, you can't just have a paper policy, though. A paper policy will actually harm you because, again, that's just lip service. You've got to have education, just like we're doing here today. You've got to teach the employees why it's safer for them and safer for you. And let's face it, management, it starts with you. If they see your supervisors, if they see the bosses talking on their cell phone, they're never going to buy in. They're never going to believe that it's really serious. And that's going to be a question I'm going to ask. I may get your cell phone records to see if you're even following your own policy. So the policy must be enforced through constant reinforcement, monitoring. You know, everybody says, well, how can I tell what they're doing? Let me tell you, your dispatchers, they know when someone's on the phone. We all know when someone's on the phone when they're talking. You hear a horn honk. You know, if you find out that someone's on their phone, it doesn't have to be you're firing them. It just needs to be reinforcement. Are you on your phone? I hope you're not on your phone. You know, you don't have to absolutely, you know, ruin a good employee over it. But you know what? You do have to have a system where you write them up for the first time. Second time, they may be suspended without pay for a day. Third time, they may be gone. I don't know what the deal is. Dave will tell you far more about what practical enforcement you need to have with your policies, but you got to enforce your policies. So what's your decision? That's what today is about. It's about Dave Teeter talking about his loss. It's about Misty Woodson talking about their family's loss. That's what you are going to be called today to make a decision. And remember one thing, and this is what I tell my children. No decision is still a decision. So that's something y'all got to think about. I thank you very much for your time.